Hello, my name is Jay Chauhan. I am a mentor at the Angel Mentorship Group, and my background is that I am a lawyer in 3 countries, including Canada, as a lawyer for several decades, and I have been a deputy judge as well, and have done many written judgments as well. And I have done CPD lectures as well as many talks to many universities and bar associations around the world, and would like to help the students and lawyers or paralegals launch their practices. And today's seminar is about how to prepare yourself as a lawyer, paralegal, or even a self-represented person for a hearing that is coming up, and how to document things and how to prepare yourself mentally for the hearing as well. Very often on legal issues, there is a need for research, and the preparation should also be made, and I'll talk briefly about that. And many of the issues that I will cover are simply not covered in the JD program, which is Juris Doctor program, LLB program, or LLM program, in terms of how to prepare for a hearing. There is usually no requirement for lawyers or paralegals to prepare for a hearing, or even preparing how to prepare a client for a hearing that is coming up. So this lecture will be very useful to those people who are new in the profession and are learning as they go. But the attempt in this seminar to try to bring points across that will speed up the learning process. So I want to start by talking about this subject. By the way, I have 2 people in the group today, members of my Angel Mentorship Group. And one of them is Bahman now. And Bahman's background is that he's a paralegal and has been a paralegal for at least 5 years. Is that correct, Bahman?
Yes, Jay.
And now Preet is about to be called to the bar. And any other people who may be joining will join the group. And we have a seminar weekly at this time, and anyone is welcome to join. So I want to begin by talking about the preparation of a hearing. How do you prepare for a hearing is based on the procedure that will be undertaken for the purpose of the hearing that you're going to do. So when you prepare for a hearing, it is very important that you know what the hearing is about. So you can usually have a notice of hearing, notice of trial, and if you're doing a landlord-tenant hearing, there is a notice that comes to you if you're the lawyer or paralegal or record, and it is provided to you and by usually in the email system and the mailing system. So you have a formal notice of what the hearing is all about. Those who are experienced will be able to simply look at the heading and know what the hearing is about, and look at the middle and then determine what the hearing is all about. For example, Rule 20 motion and what it means. But if you are not used to it, it is important that you figure out what the Rule 20 motion is for Ontario lawyers who are about to launch a summary judgment, which procedure has been changed in recent years. And you need to know what the implications are in your mind as a lawyer and what implications might be for your client. So just to summarize, actually, that you should know what the hearing is about. And the most other important part of the knowing portion is that you also have to let the client know. And it's not automatic that if a client reads the hearing, that he will know what it is about. For example, if you're doing a landlord-tenant hearing, then you have to be able to tell the client that if it's a landlord, what can happen, if it's a tenant, what kind of decision can be made, and how that decision will impact his life and what he can do with the decision he gets. So in terms of the understanding of the notice of hearing, it is fundamental that you know not only the date of the hearing, the what is it all about, but most importantly, that you convey that information to the client, because the client, if you're a lawyer, paralegal, or if you're self-represented, you need to read more on the issue, what the procedure is about, but not only what the procedure is about, what decision the judge, the tribunal, or the person chairing the meeting will have a right to make. So what kind of decision can that person make, and what implications of the decision might be on the outcome and what you might be able to do and what you're required to do. So for example, if you're in a family case and an order is made that you are divorced, or you will be required to do certain things like pay, for example, a support obligation to your spouse, it becomes a binding arrangement for the client to follow. So in terms of the theory of the law, I won't go through too much of the theory today, but in the common law jurisdictions, the important thing to recognize is that the system is adversarial. So one person is commencing the proceedings and the other person is responding to the proceedings. And when the decision is made, the decision is going to affect you in the way the tribunal judge or whoever is making the decision will affect the outcome of the proceeding. So it has a binding effect, and therefore the wording of the decision is important. So at the end of a hearing, you have to. Neil's on the phone. I'm going to take it now. At the end of the session, there is a decision that is recorded, and that decision is sometimes known as endorsement, or sometimes an order, or sometimes a judgment. But the wording of the judgment is very fundamental in terms of how it affects you in what you can do and what you're required to do. So it is very important that, just like the notice of a hearing, you prepare the client and obtain a copy of the endorsement, as I call it. And in some cases, the procedure is more detailed. In Ontario, for example, orders are written, entered, and prepared by the party that wins the motion, and the types it, has the other lawyer approve it, and then the judge endorses the record and becomes a record of the court system, and it's enforceable as a decision of the court. So it's important to understand this procedure and prepare the client for it. If you're self-represented, then you have to remember that at the end of a hearing, you're overwhelmed, you're not thinking about the subject, but when you are reaching the end of a procedure, that you do ask, if you have a lawyer or paralegal, that can I get a copy of the decision that was made? And that decision should be read very carefully, word for word, because these are decisions that are binding. So just in a common law system, as I mentioned to you, that anybody can commence any proceeding, and then the opposing party has the right to answer the question in a few days, and the days are prescribed in the different procedures. And at the end of the hearing, a decision is made, which is recorded, and it is to be obtained from the court. For example, a small claims court in Ontario, I was a deputy judge for 24 years in Ontario, and in our court in Richmond Hill, we didn't have a photocopier. So what we had to do is to ask the clerk to go in the office, make a photocopy, and instead of waiting and mailing and so on, the idea was that you could hand over the decision in handwritten notes of the judge. And as a result, I had to change my handwriting to make sure that my handwriting, which is not very good, had to be improved so that every word becomes legible and then photocopied and given to the two parties. because the two parties have to observe the wording is a part of the legal system and the decision that is binding on them. So when you prepare a person for a hearing, the important thing to remember is that every word counts. So we use a language for the purpose of describing the event, describing the judgment, describing the pleadings, and making decisions with the words, which can have a great impact. So how do you use those words is very fundamental in my view. The same description can be done in different ways, and the language that you use can make a very big difference. So I think in terms of preparation, you have to advise the client that the client understands the wording that you are preparing with. And in terms of the wording that you use to prepare the client with, and the wording that you use to describe the event in the courtroom is very fundamental. I think that also brings to me the idea of the interaction that happens in the hearing process itself. So if you have a hearing, a court hearing, most people, including lawyers who go to university, are not really prepared for a hearing in the courtroom. And there is no training to describe actually and teach the students how to prepare the courtroom hearing. Sometimes we have self-represented people who are extremely well prepared and they know how to prepare them, prepare yourself for a hearing. So in terms of the preparation, the wording, the way you speak, the way you show your demeanor, the way you show the gestures are all very important actually. So I think that I won't go in more detail on the way the hearing takes place, but in terms of the procedure that happens in the courtroom or any other tribunal, it is very helpful to describe to your client how the procedure will take place, who will stand up first and explain to the judge the summary of the case, and then they'll sit down and the opposing side will stand up, he will sit down, then the judge will make his comment on what is the next witness to be listened to, and so on. So the courtroom scene that you do see is very important to describe to the client, because the client very often, it's not very often that people go to the courtroom, so therefore it's a very intimidating experience. So if you prepare your client psychologically and say, okay, here is your role, and if he's a witness, for example, that will be in the witness box, what questions and types of questions you'll be asked is important to describe to him. So if you can rehearse those questions, it is very important to rehearse those questions and explain to the client what he might be able to say. So the same set of facts that you have can be described in different words. Sometimes the emotions of the moment, the wording explain actually how you felt and what you saw can be explained in different words, and your particular position of explanation is fundamental in the way it comes across to the judge. Because the reason why the hearings are personal in nature, in recent Corona period, many hearings are on the internet, where you can also see the face of the person and get the feeling of the expression of the person. And in terms of the lawyer who is experienced, he will know where to look at the judge, how to look at the witness, how to ask the questions, and how, if you prepare the witness properly, what response he can give should be prepared. One way to prepare it is that you create a working memorandum. If you're preparing a hearing, you can create a manual, a binder in which you have different pages, one for the examination chief, another one for cross-examination, and various questions that you will be asking the other side, because you have a detailed set of facts that you will be dealing with. And I have done a seminar before on cross-examination, and you can look it up in our Facebook also, but I won't go into detail today. The main point I'm making is that the preparation counts, and the preparation of the client that you prepare counts even more because he's new to the system. So it's not a casual event for the client. Some of these events can affect the client fundamentally in their lives, and the decision that is made in the courtroom can change their lives. So it is important that they're made comfortable and explain what to do, how to respond, how to react to the decisions, how to give the evidence, where to look when you're answering the questions, what kind of questions they will be answering, should all be rehearsed and prepared. So one word of caution to the lawyers is that the facts come from the client. The facts do not come from the lawyer. He is only arguing the case from the facts that you present to him. The role of the lawyer is to be an advocate for presenting your position in the format in which the court will accept the evidence. For example, if there's a hearsay evidence, then you cannot use that to bring evidence to the court. So it is, for example, a person said, I heard somebody say something, is not acceptable. But if you say, I saw something and I heard something myself, then that evidence is acceptable. The statements made in the courtroom are statements which are made under oath. So when you begin giving testimony, you may be sworn, and if you are sworn to tell the truth, you can affirm your statement or be sworn by under a Bible or a Quran or some other holy document, and that way you're bound by the statement that you're making. It's important that you tell your client that the statements that are made truthfully and are verifiable by extraneous evidence whenever required. So I think that that sort of covers the basic idea of the preparation of a lawyer for his own preparation to conduct a hearing, preparing the client for that hearing, and then preparing the client for the outcome of the hearing and the next step thereafter. So, Pawan, is there any issues that come up to your mind?
Oh, Jay, thank you very much for addressing this very important thing, which is we all know that even after many years, entering a courtroom has its own, anxiety, and it is an intimidating situation. Now, imagine how a client feels. It could be his or her first time. So these are the things, as you said, which we don't study in any course, or they are not covered in a textbook. But anyways, my personal feeling is that just like the soldiers who look at the commander, your self-confidence, your client also feels the same thing. If he finds you self-confident, then the same thing is conveyed to the client. Now, having said that, do you think rehearsing and practicing those questions or possible cross questions, do you think that would help to prepare the client for unanticipated situations at the courtroom?
So I think let's talk about that, Burman. So I think the second part of the talk is on the question of how the different answers can arise. So in terms of presenting the evidence, there is the plaintiff, there is the defendant, or an applicant, respondent, but always there are in the common law system two sides to the arrangement. Unless you're in mediation or an arbitration, that is, arbitration can have two sides, but in mediation, very often people can make their point, and there is not an adversarial setting. But the common law setting in terms of decision making is adversarial. So it's very important to explain to the client that you are in an adversarial setting where the understanding of the setting is important, actually. So in terms of explain the procedures, the understanding of what you expect and what you do is very fundamental. And how do you prepare for each issue? Let's say there's an issue. There are usually two issues, major issues that you have to deal with. One of them is a question of fact. Second one is a question of law. And what you're doing is combining the two to make your presentation properly. So let's just take an example that one person says that I was walking on that street, and another person said I was never there on that street. So you have two different versions of the story, and you're trying to reconcile where were you exactly. So if there's a camera, you can take a picture, you can see the name of the street, and you can identify that the person was there. The second way you can identify the person was there is that a witness saw you. I was with my friend, and he saw me at this particular street. So this is admissible evidence. It also, what I call, corroborates the evidence of the witness. And when you are using that particular fact to cross-examine, you have to prepare your client for both the eventualities. So when you're answering the question, suppose you're the witness that says, I was on that street, and you present a photograph that says that, or that street name is on the corner, and the name of the person who saw you on the street is this one. It creates credibility in the eyes of the judge, and if the evidence is corroborated by further observations of other people, it confirms in the mind of the judge that the person was on that street. And if you're opposing that position, then your point is that you have a right to cross-examine that, okay, this person looks like you, but he may not be you, for example. So you can cross-examine and say that the person had a gray-haired person like me, and the other person that you saw in the picture was with the dark hair. So if you're cross-examining a witness, then you have to see how to cross-examine the witness. So if you have evidence of the person, you can study the photograph and prepare your questions in terms of how to cross-examine. So the cross-examination issues should all be listed with evidence, supporting evidence. So if the person says that, no, I was not on that street, it's not my picture, then you have to have other corroborative evidence to suggest that he was likely to be in that place, and you can get other records to confirm that the person's identity was established because he made a comment to somebody, I was on the street, and other kinds of bits of evidence that establish what was really a fact. So the process of the examination is where the lawyer on your side then makes an observation that you talk. The lawyer on the other side has a right to cross-examine, in which event he can look for evidence or questions that diminish your credibility and try to prove the opposite of what you're trying to say. That is how the common law system operates to establish the truth. And the judge is watching to see that which side is more credible, which side is more likely to be correct, and which side is going to be believable for the purpose of concluding the decision that he makes. So one thing that is very important, that in the law is not all black and white. Actually, yes, he was there, he was not there, is not always the case. So there is the skill of the lawyer essentially is in trying to prepare thoroughly his position from the point of view of the summary that he can obtain from the client, and establish a case that is credible, strong, forceful, and then presented in that fashion with conviction to the judge, which then sways the judge to your position. So if there are several sets of facts which all put together create an event in which you take a legal position that the plaintiff was, for example, in a tort case, that the plaintiff was injured by the tort of the defendant. So if you're making a case of a tort, then how far have you gathered the evidence to convince the judge that the tort is likely to have been done by the defendant? And then you can concentrate on the damages. But your main question is that the person had the person had the obligation in the tort law. You explain to the judge your position that the defendant was the culprit who caused injury to you or your property, and therefore he's liable. So the identity of the person, the evidence that supports the tort, then the summary of the evidence, and then the conclusion of the events, and your presentation and ability to comprehend the summary of the events that is sufficient to convince the judge of your position. So in preparing the client, either you see the levels of performance of the lawyers and paralegals depends on the ability of the lawyer to understand the depth, the consistency, the amount of time used, and the analytical ability of the lawyer to analyze the law within the framework of the law, analyze the facts, put them together, and make it credible. So I think that all these things put together create the result, and then of course your reputation is a lawyer in terms of how do you present the case in the adversarial surroundings. Actually, sometimes if it's a mediation, it's a totally different role actually. Then you are simply coming together and saying that this event must be analyzed and reconciled at any cost, regardless of the way you present. So there's a big difference between the hearing in which you convince the judge through the rules of procedure, rules of hearsay, what the event was and how to interpret that event in the light of the law that you present to the judge in your, what's called a cause of action, and that your cause of action prevails because of the evidence that you presented. So in terms of preparing the client, more you explain and more you make the client understand the variables within which you are trying to operate is extremely important. So he then cooperates with you. So if I can compare it with doctors, actually, see if you go to a doctor and say, well, I have a headache, they said, oh, take an aspirin, right? The event is completed. It is very important for us as lawyers, paralegals, or if you're a self-represented person who's doing his own case, to understand that the process of the lawyer and the client interaction is very different than the interaction between the doctor and a patient, actually. So I think the variables that happen in the law are much bigger. The understanding of the process is usually lacking with many people. But I would say, let me give some examples of the different jurisdictions. I think these seminars are intended for us to be used in different countries and different jurisdictions. So if you were operating in Canada, you should identify the legal culture of the society in which you are arguing. So Canada is much more, I would say, more precise and more accurate in terms of the pleadings, in terms of the lawyers and paralegals understanding the process and presenting their cases to the judge. If you are also brought up in an educational system where you're used to the idea of understanding the legalities, then you're also more likely to be sensitive about the procedure and the process in which the decisions are made in the legal institutions of the society. Because I think that broadly, historically, that if I can just explain actually that we're following in Ontario, the English law, and at one point in time, to give an illustration actually, that even Henry VIII had to apply to Pope in Rome to say he wanted to be divorced. Now, I think the legal system over the last few hundred years have taken over the conduct of the human behavior. And there are two broader aspects of the behavior. One is civil law, another one is criminal law. The criminal law is a wrongdoing against society, and the civil law is basically a relationship between a client and another person in society who are disputing, and the balance of evidence in the two systems is different. For example, as a criminal case, you have to prove your position beyond reasonable doubt. So if you're a Crown attorney, you must establish the identity. This person did this wrong, and therefore there is no question mark in terms of what did you see, what is the identity of the person, and this is the wrong that was done, and this is the observation that was a policeman or somebody else made as a witness, and therefore that evidence is convincing to the judge beyond reasonable doubt. If in a civil case, the balance of probabilities is the standard. So what does that mean? Well, if you have evidence that the example that I gave earlier, that the person is walking on that street, then you create some doubt in your mind by saying, okay, well, Jay looks with the gray hair, but the person seen in the picture has a dark hair, so it is not likely it's the same person. So you created doubt in the mind of the judge as to who was the person walking on a particular street. So the judge has to assess the credibility of the evidence, the weight of the evidence, and the conclusion he can reach based on a balance of probabilities in a civil case, which means that taking all the observations into account, it is likely that this person walking on the street was Jay because he's got gray hair and so on. So I think it's very important that you explain the standard of the weight of the evidence required. It may be very difficult if your person is new to the legal system to explain the standard of the evidence required in terms of balance of probabilities or beyond reasonable doubt. But I think that you should attempt to explain to him, and then you take the responsibility as a lawyer or paralegal to do the preparation required so that you fulfill the mandate of the legal system in which you have to reach the appropriate threshold, as I call it, of evidence to prove your position. So what I've tried to explain in this section of the seminar is that in explaining the event to the client, more sophisticated you are in terms of the more time you spend to discuss the procedure, how it works, and impressing on the mind of the client what to do in his preparation of the evidence, the better it will be for you. If you just show up in the courtroom and say, well, I know the facts and I'll be able to describe it, it is not as effective as it would be if you were prepared and rehearsed and you did understand and you were told by the lawyer, paralegal, or you prepared yourself to be clear in your words and make your presentation properly. Now, I think one thing I should mention about Canada, as against many other countries, is that here there are two languages, but most of Ontario does mostly in English. And when you describe something, you will come across either a lawyer, as a judge, I've come across people who do not speak English as their first language. So it's very important to try to understand that it should not be held against that person that he's not fluent in that language. And what your role is in the legal system as a lawyer or a judge is to elicit the facts that are important, actually. And some lawyers and paralegals are very adept at understanding their community or other communities. There are interpreters who can help translate. But most important for you is to try to look through the language and try to determine the facts as they are, rather than make a judgment on the person and say, well, he's not very good in the language, therefore he can't be correct. So therefore, it's very important to look beyond the appearance of the person, the language ability of the person, to try to reach the objective decision, judgment that you need to reach as a lawyer or a judge. So I think that that's my experience very often is that people come in the courtroom without full language. And if you have a language difficulty, but you couldn't hire a lawyer or a paralegal, then what you can do is to simply slow down your speech, make sure that you have written it down, rehearse what you're going to say, learn the words that you might have to say, and make sure that you give the understanding, the impression that you're accurate, thorough, even without the full language ability to explain what you want to explain to the judge. At that time, it's important that when you're talking to the judge, you look straight in the eye to the judge so that he understands. So some cultures are very humble, actually. They do not want to look at the judge directly in the eye because it shows that you are arrogant in some cultures. And now nobody talks about it. So when you go in the courtroom, and if you're a lawyer paralegal, you have to prepare the client that how to make yourself felt in terms of the impact that you make, the credibility that you can create. And that also goes up right to the clothing that you wear. if you try to wear decent clothing, you'll come across reasonable. And I think there was a case in London, Ontario, where when the women first started coming into the profession, that she had a very low-cut dress. And the judge simply declined to hear this woman. She's a woman as well. She declined to hear the woman and say, look, dress up properly and then come back. And I think it's reasonable because the courtroom is a very important place where the decisions on the lives of people are being made, so that how you present yourself, how you dress, and how you express yourself are fundamental. But all these issues, Brahman, as you pointed out, are never discussed in any of the training programs, but can make a very big difference. So those lawyers who are experienced make a quick comment, oh, come dress in a suit, and then leave it at that, actually. But I think that when we become, as a Ontario and GT area, become very multicultural, and we have to try to learn through the lens of the society, which is adjusting to multiculturalism, where we need to look through it and not only help the system, help improve the system by making not prejudgments on the people based on how they look and how they dress and how they speak, but also try to find the facts as they are and not make any presumptions on them. So that is a learning skill, actually. And so I think we did recently a seminar of the Law Society where these things are being discussed. It's called EDI, Equity, Diversity, and Inclusion. So the lawyers are being trained to understand. As a judge, we were trained also for how to deal with self-represented and how to deal with the clients who are appearing on their own, and they're not well versed in their ability to explain themselves in the language very often, or even the words that they use. And I think it's not, the other part that I want to emphasize is that just because we are using a language for long enough, there's an assumption that we have the skill and ability to explain ourselves properly on the ideas in the language because we were born and raised in that language. It's not the case, in my view. I wrote for that reason a novel in English, although English is not my first language. And I had to perfect my language in terms of the English because that's the language I function in. And I've written many judgments in Ontario, and the wording that you learn to express in a novel, for example, is very different than the language you use in the pleadings. But even the pleadings are not taught in the school in terms of how do you draft a pleading? What is it that you say? What does the form look like? None of them are explained in the school, actually. So first time when we teach the students in my angel mentorship group, we teach the students the form. The statement of claim will look like this, and you fill out the blanks in the small claims court form because the form prescribes how you'll explain yourself. If you're in superior court, you'll have a style of cause, and you'll have a particular kind of format that the plaintiff claims: A, the following; B, the cost; C, the interest rate, whatever. This, after spending for lawyers, first degree, second degree, by admission course, the student can come out not knowing even how to present a statement of claim. And I think paralegals go through also several years of studies in a community college, but also not fully. But they are much more prepared, Brahman, in my view, than the lawyers are on the nitty-gritty of the form. So when you, for example, in my experience, the form for statement of claim is explained to the young lawyer, you have to go through it a couple of times to explain that it has to end up with the names of other party at the bottom left side. Your signature gets to on the right-hand side. It may look very small and insignificant to a professor teaching the law, but when you practice, it is fundamental, actually. Because if you didn't do it in the right place and didn't do the backing, as you know, Brahman, to the court, then the clerk will tell you that is not acceptable. You may be filing the document the last day, and it cannot be filed because you missed out some form, which is not correct from the court point of view. And then before you can even reach the judge, you are doing the filing, it's not even acceptable. You can miss the time limit. And now you've got a negligence claim, and nobody's explained to you that it is not sufficient to know the theory of tort. It is important to understand how to explain that tort, realize your cause of action, how to understand the damages, and how to understand the form until you complete it to the point where the court will accept it, and there'll be a day when you'll get the hearing. When you get the hearing, you have to then prepare. That's what this seminar is about how to prepare. So I think these things are incidental. And on each one of these issues that we mentioned about the form, the main thing that we try to do in Angel Mentorship Group is to try to give the experience and observations on the system of issues that are not taught in the school or in the bar admission course. So I think I think that if I can just point out one thing, Baman, in this case, I'd like you to comment there also. And if Yannick wants to have a say, she can say it as well.
There are so many things, Jay. I wished we could address. We could get you to talk about them, but I don't know how much time we have. One was from as a retired deputy judge to talk about the hearing session from a judge's point of view. I have seen some of my clients, they get frustrated because they don't know the common law system. They come out at the break time and say, this judge is just sitting there, passive, and they expect the judge to jump in and take an active role. That means nobody explained to them how the common law system works. And they sometimes get frustrated. They think the judge is ignoring all these things while the judge is taking his own notes. This is something I wanted you to mention here, to be conveyed, to be discussed with the client, to understand how the system is working. That was one of.
Let me talk about that for a few words, actually, because it's very important that in Ontario, we are sensitive to other jurisdictions and the experience culturally for the people. So if you come from a jurisdiction in the Middle East, where the legal system is entirely kind of civil law, religious law approach to the legal system, there, the whole approach of the judge is very different, actually. The judge interacts, he inquires, he finds out. Is a civil law judge, like the French system, for example, is the initiator of the proceedings, and he's inquiring into the system. He's interacting actively to try to find out the facts, the truth from the lawyers who represent the two different parties. So it is very, very important to understand the different system. So here is what our challenge, Baman, is not just administering the system in Ontario and saying, okay, I'm the paralegal of Ontario, I'm the lawyer of Ontario, therefore I don't really know or care about other systems. But the reality, as you saw in your practice, Baman, is that if your client comes from a jurisdiction where he does not have the exposure to the system, and the system affects you so drastically and so deeply, you need to be able to say a few words to them that, look, the judge is not involved as heavily in the common law. It's like a referee watching the two sides, and the lawyers play a more dominant role in the common law. Now, if you're in a jurisdiction and you want to make an argument in the civil law system or even religious law system, you recognize the values of the system and the values of society, which emphasize a certain point of view. So, for example, if you're saying that society does not have the religion, for example, it has the religious system, you have to be sensitive that your role as a lawyer in that system is to recognize the sensitivity of the society and how the society, through the judge, is imposing the value onto the client. But if he comes in Ontario, you have to shift him in your thinking process from the jurisdiction he's used to make him comfortable in the jurisdiction where the lawyer does play the dominant role. At that time, Baman, it is my view that you have to be able to say to the client that the lawyer is not the decision maker. So very often what happens in Ontario is the expectation of the client, especially from the non-common law jurisdiction, that you're performing a bigger role than you're supposed to. So I think that if you, for example, so it is our duty then to educate the client. So I had a lot of clients from Iran, for example, and different Middle Eastern countries, where you had to emphasize that the role of the lawyer is to explain the proceedings, prepare the evidence, but to emphasize and explain to the client that the jurisdiction is not civil law, where the judge will be active. He will be wondering why, for example, if you're advising a client from the Middle East, actually, well, why didn't you object? Why didn't you stand up and say something to the judge at the time when he made a comment? Because in the common law is a slightly dignified system. So I put on the gown to sensitize the other group as well, Paman, that it was developed historically in the English jurisdiction, where the upper classes who were barristers, I'm a barrister in the English jurisdiction, as you might know. The barristers in the Lincoln's Inn where I went were trained to sit there in the dignified form with the gown, the judge in his gown, and in England you put on a wig, to say that I am listening to your evidence, I will listen to it objectively, and I am not emotionally involved in the process, so I'll make an objective decision based on what I gather. So the culture of the law that Ontario has is inherited from that jurisdiction of England, where the objectivity, the calmness comes from the years and centuries of experience of the judge who is dispassionate. But what we have to recognize in Ontario is that we have people from different parts of the world who will not be as dispassionate, actually. And therefore, they have different expectations in terms of how the system works. What is it you do to prepare them? And you can only do so much to prepare them, because how much time do we have? But because it's heavily laden with common law, and that the immigration process is more dominant in terms of the immigrants from the non-European countries only in the last 30, 40 years, that we are in the middle of changing the system. It is my view, Baman, that we have a duty not only to understand the law, but participate in the events in which we can create the idea of understanding the system and even improving the system as we go. Not only by educational seminars like this one, but also with the clients each time you have an opportunity to explain it to them, who in turn explain it to other people. And that we have a system of integrity, a system inherited from England, and a system that recognizes and acknowledges in the Multicultural Act all the different ethnic groups of the society. And then we are trying to be respectful to each jurisdiction, but we can be respectful only if we understand them and explain to them how the system works, which affects them very profoundly. So I think I just want to turn slightly, unless you have a question, any one of you, feel free to ask, but if not, then I want to move into research issue, actually, why it is becoming important. Any questions, Parman?
There was another issue I was going to bring up and ask for your opinion. That was for the lawyer or paralegal to keep the client updated on what has been happening, because sometimes at the break time, my client says, what are you guys talking about? His English is good, but all these terms, 11B, you said that is res judicata. What are these things? So that's part of our job to, at the break time or end of a hearing, brief the client how far we have gone, maybe with what has been happening since this morning, with all these witnesses, everything. Now we have to change our strategy. Maybe it is time to settle. We are not as strong as we thought yesterday. So to be honest and professional with the client and keep them abreast of what has been happening, I think that's something we have to stress.
Well, let me address that issue, Baman. Very good point that you raised, actually. See, so I think today my emphasis in the talk was how to prepare for a hearing. But I think that even within a hearing, there can be a break. There can be a lunch break, and then you resume the hearing. Then there is the decision at the end. But very often, the decision at the end, for example, Rule 20 hearing, then there is a whole follow-up on that situation. So within the hearing, at the end of a hearing, there is another set of things that you have to do. Suppose you have judgment to collect and have judgment for a small claims court for $35,000. So it is not the end of the story. So the question is, what do you do after you obtain the judgment? So you have to have another sit-down meeting. Well, the client will say, who's not familiar with the system, well, I thought I would get the money now. But it's not that automatic. You have to garnish the order. You have to go and enforce the order, realize the property, and therefore, in different words, at every step of the way, you have communication between the lawyer, paralegal, and the client. And if you're self-represented, your reading is required to be on what is the next step that's going to happen so that you prepare the person for the next step. And then in our case, the biggest thing that challenge which I repeatedly said, which is not mentioned in any of our education program, of the right from bar admission to JD to NCA, is that we are in a private enterprise legal system, which means that when you need a lawyer, you have to pay the lawyer or a paralegal to get your job done. So here's a system of law that affects your life profoundly, but then you must pay for accessing the system. If you go to medical system in Canada, you are mostly covered by OHIP system. So people get into their mindset actually that why is it costing so much? And the paradox of the system of the paid legal service is not only it's in competition mode or pay for service mode, but also a situation of competition where if you want to learn a skill, a specialized skill in an area of law, let's say litigation or estates, you must learn it in the adversarial environment. So when you go to a seminar, you learn that thing. But does that learning teach you everything you need to know in that 1 hour? It does not help you to learn everything, because a lot of the issues that we are learning are cultural in nature as well. Just like you pointed out, actually, that your client from Middle East says, well, how come you didn't stand up and assert yourself and interject and do something actively to support my position, right? So at that time also, you have to try to understand actually that that in terms of the sequence of events, the amount of interaction, culture, language, there are so many issues that we must deal with that are not possible to teach them all at one time to different groups of people and do it in a private enterprise system. So how much do you teach? That's why we started this Angel Mentorship Group, where we want to prepare the lawyers in a multicultural environment to explain to them that when you're launching the practice, when the jobs are not around and there is Corona and you're not being hired just because you're a lawyer, is because the legal education does not prepare you fully for the practice of it. There's not a single lecture that you'll get on how to do the social media marketing. In my time, you put an ad in the yellow pages and the clients came to you and say, well, you're a lawyer, right? So today, there are thousands of lawyers. In my time, there were 6,000 lawyers. Today, there are 56,000 lawyers in Ontario. So just that goes to show is the competition that you have to pay. But as people get experience in their profession, they get more expensive. Those people who really need the support do not necessarily have the resources. So the big lawyers, so to speak, end up talking to big corporations, and where the lot of legal thinking, ability, sophistication ends up supporting the big corporations. And the small person in a family type of situation. So let me explain that part in a little more detail, Mama. I wrote an article to explain that about 65% of the people going to family court in Ontario do not have legal representation. A large number who have legal representation basically fire their lawyer because they're fed up with the system. The system itself is adversarial. And from my point of view, the family law is not very conducive to the adversarial environment, because when the family falls apart, there is an adversarial setting which enhances the conflict zone rather than reduce it. So I recommend a committee system where you sit together, a psychologist, a financial consultant, a lawyer, and then bring that consensus of what should happen to the judge And then the judge can make a decision, and you can bring the evidence only when there is a dispute on an issue that people cannot agree on. So I think we are also engaged, Bahman, in terms of, we as lawyers, just like doctors are, many doctors came up and made comments on the corona, but I saw very few lawyers make comments on bigger issues, like if you're a legal system of Russia and want to invade another country, how does the rest of the world react to the international law? So we just too engaged in the private enterprise system to work on our issue, to make a living, for us to think about the bigger issues of law reform, for example, and understanding different legal systems, that we are very fortunate that we have a legal system that is objective, consistent, reliable, but it's private enterprise. So we have legal aid, but the legal aid does not cover the vast majority of the people in the business arena, where a lot of people are now working. I would estimate that 30% of the population now are self-employed. And if they get into some difficulty, then they do not have the recourse of the legal system usually. So I'm starting a program, by the way, in which we will provide half an hour free to business organizations. And we had a seminar recently to address that issue. So I'm saying to all the lawyers in our group that we as lawyers have a duty beyond the duty taught in the rules of professional conduct in the society. And if we make comments, lectures, written articles, we are moving the system forward. For example, if I believe that the family law system is not very good in the adversarial environment, then I should be able to make my point, and I should find the time to make my point to the society that it should be done by a committee system. So, for example, real estate, actually, in my view also, the real estate was plonked into the common law system in the adversarial environment. So we have a vendor, a purchaser, and two different lawyers. If you go to Quebec, you don't need two lawyers. In estate law, you don't need two lawyers. So how much of that thinking from civil law can we bring to common law and enhance our legal system? So I feel that just like doctors do, we have a monopoly of knowledge. We spend, I would estimate, roughly 10 years. I was a slow student, Barman, but I spent 12 years of education to be a lawyer in Ontario. And I became a lawyer in India and England as well. It took me lots of time to do it. But the point is that after 12 years of education, what contribution can you make to society? How many people have the time to spend 10 years of their life and then make a contribution to society with the lectures they do, and then make a contribution to reform and help, like doctors are doing it. Doctors have lots of funding to research on cancer. How much funding and how much participation do we have from the average lawyer to improve the legal system that we are in? Do we ever address that issue in any of the situation that we're dealing with and say, here is what we as a group. So I would like our angel mentorship group to contribute some articles as I am doing and help I'd like other people to assist me in publicizing the issues that we're facing and how can we help improve the system as a whole. You know, it's not just be relegated to other people, but we are responsible citizens, have a duty owed to the society because we have the privilege of getting that knowledge. So I think it's nearly 1 hour since we started. I really appreciate Yannick, Preet, Adran, and Paman attending the seminar. And
Thank you very much.
like, if there's any questions and want to prepare for the next session. And I think if you think Wednesday is not a good day for everybody to attend, we'll move it to another day. But I really appreciate your coming and attending. And any questions that you have?
Thank you very much for everything.
Yannick, if you're listening, any questions you have?
Mute.
Adran, do you have any question?
No, Jay, just listening in.
Oh, excellent. I'm glad that you're there. And hope you will join another meeting. So I'm going to call the meeting off and then we can have a short dialogue after that.